Monday Morning Matters.
Perspectives
from Southeast Asia.
Hi, this is Arlene and you are listening to Durian ASEAN, the voice of discovery and sharing. Today we are going to talk about a topic that has rocked the world as well as Indonesia and Australia. I'm talking about the Bali Nine. It is a name given to a group of 9 Australians convicted for smuggling heroines valued of around Australian dollar 4 million. And ringleaders Andrew Chan and Muran Sukumaran were sentenced to death and were executed on 29 April 2015. Other members were also imprisoned. One of the lawyers that have been working really hard on the case was Julian McMahon. He is a Melbourne barrister and has been the lawyer for other cases of death penalty and drug trafficking. And of course, his most infamous case was the Bali Nine. And McMahon will be speaking to Durian ASEAN on this particular topic, and he'll be sharing with us on his experience working on the Bali Nine case, as well as his views on drug trafficking and death penalty. First of all, thanks for accepting our interview at Durian ASEAN. My question, as a lawyer, what has been your experience working on cases involving drug trafficking and death penalty?
Most of the cases that I've worked on which involve the death penalty have actually involved drug trafficking. The only exception was a case in Sudan in Africa, which was a murder case where the death penalty was on the table. Eventually the court acquitted my client and the 4 people involved in that case. But in our part of the world, especially in the ASEAN countries, it's quite common for a death penalty case to involve drug trafficking, and certainly where the Australians have been caught up in allegations of crime or actual doing crimes and face the death penalty, pretty much invariably it's a drug case. And I've worked on a number of those in the region, in the ASEAN region, over the last 10 or 12 years. What my experience in death penalty cases has shown me is, without any doubt, I think without being judgmental or morally judgmental about it, it just seems to be so obvious to me as I watch people who have been taken away and killed, is that it's the wrong thing to do. And there are many arguments for it. I don't think there's one simple argument which explains why the death penalty is wrong. Perhaps you could say that it's wrong for the state to kill people, and although that does persuade me, of course it doesn't persuade everybody, but it's wrong for the state to be involved in unnecessary brutal acts. Everybody involved in an execution is tainted and damaged by it, and the state is damaged by it. And of course there are the obvious reasons, such as innocent people can be killed, and there's simply no doubt that that happens. The amount of analysis and research done around the world on that makes that very clear that that happens. In America, in recent decades, something like 1 in 25 people on death row have eventually been exonerated or acquitted on the basis that they were wrongly convicted.
What is your personal experience meeting and representing your clients, Muran Sukumaran and Andrew Chan, and why the Bali Nine case is significant?
Perhaps the main reason that I'm so determined to assist people in death penalty cases is because of my experience with clients who have been executed. When I had a client executed in Singapore in 2005, and I was with his family as they were taken away after their last visit, and I was at the prison the next day when he was executed. And he was a lovely young boy. He's an Australian who had certainly done the wrong thing and was guilty of drug trafficking, carrying drugs through Singapore from Cambodia to Australia. But by the time he died, he was a completely reformed and good young person. He was only interested in doing the right thing and good things for his family and for other prisoners and for the guards around him. So as the time came for him to be killed, and when he was killed, it was very obvious to me what a senseless and wrongful, unnecessary, brutal act that execution was. And I think at that time I realised with really, for me, a great clarity that it was wrong for the state to indulge itself in state-sanctioned killings of people, prisoners who were locked up and detained. There's no doubt that, in my mind, that prison can always be enough punishment. Some people might deserve prison for 5 or 10 years, some much longer, and some may be so dangerous that they simply can't be let out of prison for the rest of their life. However, as I've been really quite deeply involved in cases of this kind and studied them around the world for quite a long time now, nothing has ever convinced me that anything more than prison is required. I don't believe in the need for torturing prisoners to punish them. I don't believe in the need for caning prisoners, which is a form of torture, in punishing them. And I don't see that the state needs to kill people and thereby degrade itself and the people involved in that killing.
How had the Bali Nine case evolved since the day you represented them on 2006 until the day they were being executed?
In 2005, when 9 Australians were arrested for trying to export heroin from Indonesia to Australia, in April 2005, they became known as the Bali Nine. In the next 12 months or so, they were sentenced to death 3 times as their case went through the courts. And at about the time of the 3rd sentence to death, which was a Supreme Court decision, the families of Myuran Sukumaran and Andrew Chan asked 2 Melbourne lawyers, Lex Lazary QC, who is now a Supreme Court judge, and myself to get involved, which is what we did. We went to Indonesia, and we were very, very fortunate to be able to meet with one of Indonesia's best lawyers and a very courageous and honourable advocate, Todong Mulya Lubis. After long discussions with him, he eventually agreed to become involved in our case. He certainly wasn't keen to become involved because it was a drug trafficking case and he had no sympathy in any way with that kind of criminal activity. On the other hand, he saw it as a bigger picture, as the question of whether the state should kill people. So it was a death penalty case, and on that basis he was prepared to get involved. And then he was the senior lawyer in the case for the next 8.5 years until our clients were executed on the 29th of April 2015. When I first met my clients in 2006, they were not impressive young men. They were silly young men who had been involved in crime and were not prepared really to openly face up to what they'd done. But that quickly changed, and over the years that followed, they began to lead exemplary lives, and it's well known, very well publicised, the kind of things that they did. Perhaps the strongest evidence of the good that they did came from the wardens of the prison in Bali where they were. That is, at their hearing in 2010, many years later, the warden of the prison came along and gave sworn evidence in full uniform and under cross-examination from the prosecution, gave sworn evidence that their clients should be allowed to live in his opinion because of all the good that they do. There's no doubt that they were transforming Kerobokan Prison in a positive way by teaching and training and coaching, counselling prisoners in need. And as events unfolded in the next few years, it became very clear that the work they did was truly valuable and inspirational in that prison. One of the saddest things about the execution of my clients is the failure of the authorities to ever give consideration to how good they had become and all the good work they were doing, and more importantly how they were helping so many other prisoners, usually very poor people, to get their lives in order and to get skills and for jobs when they left prison. It really was such a senseless thing to kill such valuable assets in the prison system. So the sorts of things that my clients were doing involved, with Myron, especially with art. He organised artists to come to the prison and teach art classes, and quite a few of those prisoners now have left the prison and make a living painting art, which is a fantastic thing to see. And even up until when Myron was executed earlier this year, numerous of those prisoners would come back into the prison as visitors on the days when art classes were being held, because the art room was a safe place, it was a good place, teachers came and skills could be learnt, which would carry prisoners through life. So that's a great thing that Myron did. Andrew Chan was much more interested in religion, and he was very involved in the chapel in the prison and counselling people, obtaining help for them. Both my clients, Andrew and Myron, would often very privately, and many of these things are still only known to a small number of people, would obtain money from visitors or contacts to pay for medical expenses for these prisoners who were so poor they could not afford essential medical services. Myron would sell paintings to pay for operations and so on. Andrew also organised cooking classes. His parents were cooks, Chinese food cooks, all of their life. And Andrew was a good cook. He'd learned it at home and in the restaurants and so on. And he was teaching hygiene and food management and how to prepare meals to present them beautifully to prisoners. These are skills which the prisoners can then use when they get out of prison for the rest of their life. There were also many other classes ranging from philosophy to first aid to English lessons and so on. So what Andrew and Myron did was a great thing, and they did it over many years. And that's why the wardens of the prison over the years, especially say from 2010 to 2014, those wardens were prepared to publicly speak on behalf of our clients and say what a great asset they were to the prison and that they should not be executed.
Monday Morning Matters.
Perspectives
From Southeast Asia.
Why did Indonesia court continuously turn down their clemency plea? Do you think President Jokowi has turned the issue of death penalty into a political issue?
There was a very long and almost tortured path through the courts in the case of Sukumaran and Chan. Before the Australian lawyers got involved from Melbourne, they went to court 3 times and in February 2006, April 2006 and August 2006, they were sentenced to death in 3 different courts. And it's then, only then, that we got involved, and I suppose in a way the damage had been done. We took the case to the Constitutional Court, and the lawyers, the Indonesian lawyers, Mulya Lubis, for a whole year argued that case. They brought in experts from around the world's leading experts on questions of the death penalty, the relevant international treaties, the laws that Indonesia had implemented and signed, and the argument was that the death penalty had become unconstitutional because of the new human rights laws which had put into the constitution in Indonesia early this century in the period of time known as Reformasi. Now, eventually, the court was divided down the middle. There are 9 judges, and 5 of them favoured retaining the death penalty, and 4 of them opposed retaining the death penalty. And one of those 4 was the Chief Justice, Jimli Ashidig, and he later said that he signed on with the majority of 5 because he felt that it was his duty as the leader of the court to side with the majority. Following from that decision in 2007, which was so narrowly decided, there was another court case in 2010 called a PK, which was like a final appeal in the Indonesian court system. That decision came down in 2011, and it again said that the death penalty should proceed with these 2 clients. But unfortunately, of the many arguments that were raised in that case, the decision of the court only dealt with a small number of them, so many of the main arguments were simply not addressed in the decision. Following on from there, it was time to put in clemency applications to the President, Susilo Bambang Yudhoyono, and they went in to the President's office in 2012. Now, under Indonesian law, they should have been decided in that year, or by early 2013, but for whatever reason, they just sat there, and they were not decided even up until when the Indonesian elections took place and when the presidents changed to the new president, President Joko Widodo, who came into office in October 2014. Now, in the lead-up to the presidential election, President-elect Joko Widodo had never spoken about drugs or the need to execute drug dealers. He had spoken a great deal about corruption, and he was very opposed to corruption. That was what he campaigned on very heavily. Soon after he came to office, by about early December, he began to say that, almost out of the blue and to the great shock of the international community, he began to say that there are 64 people on death row for drug offences and they'll all be executed. That came as a great shock for a number of reasons. One is he'd never spoken like that before. Another reason is that many of those 64 had cases still in their system, so how they could be executed even though their cases were ongoing obviously shocked the legal community that people would talk that way. And as quickly became apparent, the President did not seem to be aware of the details of the cases, and so he was making a blanket political statement. That is to say, if you're on death row for drug offences, you'll be executed, and I don't care about the details of your case, and I don't care about your clemency documents and so on. And in fact, what's happened since then is that 14 people have been executed, despite all kinds of efforts made on their behalf by different lawyers, both Indonesian clients with Indonesian lawyers and also people from around the world. For reasons which have never been explained, most of the people executed have in fact been foreigners. In January of this year, 2015, when my clients Andrew Chan and Myron Sukumaran were told that their clemency application had been rejected, we took the case, and that's despite what seemed on our analysis, and on an analysis which has never been contradicted by any Indonesian court, the overwhelmingly strong material to show that they were remorseful and that they had rehabilitated. Now, that remorse and rehabilitation is very important because the 2007 Constitutional Court decision said that if people on death row do show remorse and do rehabilitate themselves, and they do that consistently for a long period of time, then after 10 years they should be resentenced and they don't need to be executed. So that's exactly the position of my clients in accordance with the decision of the Constitutional Court. That's another reason why the decision to execute them was so extraordinary and why we tried to fight against it in the courts, although we were unsuccessful. So once the President had decided in January 15 to refuse clemency to Australians, the lawyers for the Australians sought to file what's called a second PK, a second appeal in the Supreme Court. And the reason they did this was because the Constitutional Court in 2013 had said that in certain criminal cases, and our clients fitted within this case, a second PK could be filed. However, despite trying to file it and have the merits of the case heard, the court would not hear the case. So then a decision was made by the lawyers to take the case to the administrative court. And this is because, as a matter of administrative law, the argument was that the President was obliged under Indonesian laws to read the documents concerning clemency before he rejected clemency and ordered execution. That was the argument that was put. However, the administrative court said it had no jurisdiction to hear the case. So sadly, once again, the merits of the case were not adjudicated. That decision was appealed to the appeals court within the administrative court, and the appeals court reached the same decision, said it was not a matter for them, it was a constitutional law question. So accordingly, the lawyers for Sukumaran and Chan, together with a number of other interest groups in Indonesia, filed a case in the Constitutional Court. However, before that case came on, the clients were simply executed. Again, that was a process which shocked the international legal community. One of the other issues that emerged during 2015 concerned the lawyers who initially acted for Sukumaran and Chan for the two Australians. That's to say, they had nothing to do with us Australian Melbourne lawyers, but they were the lawyers in the case at the beginning. One of them went to the prison in 2015, unannounced and unexpectedly, and emerged from the prison and gave a press conference where he alleged serious issues concerning corruption. That was in February 2015. As a result of that, documents were sent to the Judicial Commission to conduct an investigation into corruption. Very sadly, and again to the shock of the legal community and the international community, before that investigation could seriously get underway, or before it was seriously underway, the relevant prisoners were executed despite the allegations concerning their case. It's not appropriate for me to talk more about that because that investigation is ongoing now. So you can see that the case of the Australians went to the front door of numerous courts, but especially in the year 2015, at the second PK and at the administrative court, we effectively were not able to have the merits of the case argued. However, the case is now proceeding in a different structure, but the ideas are still proceeding before the Constitutional Court, and we'll see what happens there.
Why do you think that the Bali Nine case is significant to Australia, and how has the case shaped the public opinions among Australians?
Well, Australia actually stopped executing people in 1967, and since then Australia has not cared very much about the death penalty, it seems to me, mainly because it's one of those things that happens somewhere else, and it hasn't really excited a lot of public opinion. In 1986 or 7, there were 2 Australians executed in Malaysia. Again in 1993, 1 was executed in Malaysia. Then 2005, 1 Australian executed in Singapore. And this year, 2015, 2 executed in Indonesia. So you can see that it's something which doesn't happen very much. However, what happened this year in Australia was quite significant because for the first time the country really came together. There were virtually no disagreements in the public debate about whether the executions of the 2 Australians was the right thing or the wrong thing to do. Of course, there were some differences of opinion, and some people were saying, okay, go ahead, but overwhelmingly the majority view was that the executions would be the wrong thing to do for a number of different reasons. For some people it was because executions are wrong because the state should not kill people. It should not sanction, quote-unquote, the killing of prisoners. For other people, the case had a different dimension as well, which is that the 2 Australian prisoners were actually very reformed, and there was no doubt about their reform. There was years of documentation and study and testimony about it, and so a lot of Australians felt that there was something wrong and unjust, deeply wrong, about killing reformed prisoners, especially since Indonesian law so openly encourages that kind of reform and rewards it generally. So the debate got to the point, for instance, where, if I remember correctly, every living former Prime Minister, about 5 or 6 of them, openly spoke against the execution, and Parliament on both sides of the House in Australia, as your listeners would be aware, the government changes regularly in Australia, and both the opposition and the government are usually in similar numbers in the House. It's often hard to predict the outcome of an Australian election, probably more often than not. Anyway, the point is that parliamentarians generally in Australia gradually found their voice on this subject and were opposed to the execution for the sorts of reasons that I've said. So many things followed from that kind of public debate. There were a range of things, ranging from art shows or concerts or petitions. I think the main petition had about 250,000 signatures on it, and various representations were made. There were documentaries made and TV shows. I would say, without any doubt at all, the overwhelming nature of that voice from Australia was respectful to Indonesia and courteous, but nevertheless saying that we as a country thought it was wrong to execute prisoners, or in this case particularly prisoners who were so plainly reformed. Now, unfortunately, there were other forces at play, and ultimately, of course, they were executed. I think some people will say, oh, this was just a question of the courts and the law being applied. Generally, there's much more to it than that for the execution, certainly of the 2 Australians. The clearest example of this is what happened in early March when the 2 Australians, Sukumaran and Chan, were moved from Kerobokan prison to Nusa Kambangan off Java, the island off Java, where the many prisons are. I think there are 7 prisons on the island, and where executions take place. Now, in order to move the 2 Australians, who had been known for years to be completely law-abiding and helpful prisoners, who had conducted many classes and teaching and all sorts of good things in the prison, where the prison wardens and governors praised them publicly and openly for their good deeds. In order to move the 2 Australians, there was a kind of a bizarre military extravaganza. There were fighter jets flying low over the prison and circling, armed with what appeared to be live missiles. There were warships circling Nusa Kambangan. There was huge numbers of heavily armed personnel, armoured personnel carriers, all this kind of stuff going on, to move 2 completely contained and well-behaving prisoners. Now, generally, those actions were seen around the world, not as being necessary for part of the law and order within Indonesia or as part of the war on drugs or as a necessary way to move two prisoners from one prison to another. It was obviously something else. And, it was all about internal display of might, I suppose, and there are different interpretations put on those events, but whatever else it was, it certainly wasn't simply a case of applying the rule of law and moving two prisoners from one prison to another. So in answer to your question, that's one of the more obvious examples of how this case, in the minds of and in the actions of some people, became something different from an appropriate exercise of the normal powers which are needed to deal with these kinds of problems. It was obviously complicated, so that's probably an indication of some of the complexities of the matter.
Mr. McMahon, my final questions. So, how has the case implicated Indonesia-Australia relations?
Well, in a way, I'm no more suited than the next person to answer that question. At the end of the day, I'm just an Australian lawyer involved in a case helping Indonesian lawyers, and that's it. I often think it's a bit silly the way some people feel they can comment on everything. That's what the Hollywood movie stars do, comment on everything. But I can make some observations about the relationship. I, for one, after all my visits to Indonesia over these years, I certainly love Indonesia and I look forward to going back. I think it's a fantastic country, and I look forward to it growing in so many ways over the next few decades. It looks to me like it has the capacity to just steam ahead and for so many great things to happen there. What the Indonesian press sometimes said, and the Australian press, there was obviously some tensions there, but there's no doubt that, in my mind, that most Australians would certainly only want goodwill between the two countries, only want mutual friendship and prosperity. I have a bunch of kids, and I want them to grow up enjoying travelling to Indonesia and having Indonesian people come down to Australia and travel here, and friendships are made and so on. That's the only way to plan for the future. Any other way of planning for the future is just not good enough. There's a long history of disputes about which I'm not competent to talk about, and even in the last year or two, the ambassadors from each country has been withdrawn from the other for a period of time. In the Australian case, actually because of this case, the Sukumaran case. But overall, and if I could speak for the majority of people, certainly the people I know in all kinds of life, ranging from politicians or diplomats or lawyers or people in the arts community and so on. I have areas of interest in all kinds of parts of Australian life. Mutual friendship is the thing that we want most of all, and I have no doubt from the overwhelming number of Indonesians that I met that the same is true. Sometimes politics gets in the way of good decision making, but hopefully those things are only temporary bumps in the road. And I hope for for the future that we see more and more actions of friendship. It's great sadness to me that my clients were executed, and I think it was the wrong thing to do. And I'll certainly do what I can if there was some way I could help other people not being executed. But at the same time, it's a great sadness to me if countries like Australia and Indonesia don't work together as cooperatively as they can So to put that in a practical way, I'd love to see Australian, say, journalists and lawyers and politicians or retired judges and so on visit Indonesia more and more and share what skills we have here with Indonesians. And I'd love to see all kinds of Indonesians coming to Australia and doing more and more education about Indonesian culture and history and so on. There's no doubt, and it's not an anti-Indonesian thing to say this, because I learned this from the Indonesian press, but there's no doubt that the biggest problem, as I see it, in Indonesia is fighting against corruption, and that's what the Indonesian media says almost every day in one way or another. Now, Australia has many faults, and I probably know more about them than many of your listeners, but overall, Australia does not suffer from endemic corruption, and so that would be certainly one area where I could hope that Australian skills such as the training of judges or the accountability of politicians and so on is something that much more work should be done on. These are ideas that I learned from reading the Indonesian press. These are not ideas of criticism that I learn in other countries about Indonesia. The Indonesian press, to my surprise, and sometimes I'm very surprised at the open accusations they make, are constantly calling for improvements in the face of this scourge of corruption. And having been trained as a lawyer and having 2 degrees in law and many years practice in law, I can confidently say that this is an area where our senior judges and our retired judges could be of use in explaining protocols and procedures and ways of identifying and fighting against this kind of activity. But there are so many other areas, education and sport and music. They're all great fun things that we should be joining together as 2 countries as much as we can.
It was a pleasure speaking to you, Julian McMahon. Thank you.